really just going to say hello.
How is? Sure.
Yes, I know. Conferences. And then it's in the order that's there.
Just to, yeah, perfect. Yeah.
And we have Philip Spurley as well to introduce him.
Always bring the brief.
So good afternoon, everyone. You're all very welcome. Thank you very much for coming along at such a busy time of year. For those who don't know me, my name is Siobhan Mullally, and I'm Director of the Irish Centre for Human Rights at NUI Galway at the School of Law. So we're really delighted to host today's public lecture, which is part of a series on climate justice that we launched this year jointly with the Ryan Institute at NUI Galway, and that's bringing together lawyers and scientists to look at the whole question of developing legal responses and human rights-based responses to climate change. And the initiative grew out of an event last year with former President Dr. Mary Robinson, who spoke in Galway and called on us to take more urgent action and to use the tools of human rights lawyering to respond to climate change and to develop those skills that are needed with greater urgency. It's also drawing very much on the work of our keynote speaker today, Professor Philip Alston, UN Special Rapporteur on Extreme Poverty, who I think you all know and who's been very active this week also on a whole range of human rights issues and working on sustainable development goals and human rights-based approaches. And the Special Rapporteur's report earlier this year on climate change and poverty highlighted the inequalities in terms of the impact of climate change and the need for human rights lawyers to get their act together really in terms of more urgent action. His report was highly critical of lawyers, of human rights advocates, because of their focus on what he called proceduralism, managerialism, incremental change. And he really called on all of us to think more deeply and more seriously in terms of the science impacts in learning about climate change and using the tools of human rights law to respond to climate change. So that underpinned bringing together today's event. We're also very mindful, of course, of the gender dimensions of climate change, the impact on women and girls in particular, who are often more deeply harmed by climate change and situations of poverty. And also in the context of Ireland's work on overseas development, a very strong track record. But as the Special Rapporteur noted in his report, there is a risk of climate racism and climate apartheid in terms of failing to recognise the disproportionate impact on poorer countries of our own inaction in relation to climate change. And that was something that the Irish Centre for Human Rights raised in our shadow report to the UN Committee on the Elimination of Racial Discrimination. Ireland, as you know, was reviewed just 2 weeks ago, and we submitted a shadow report which highlighted that inaction in terms of Ireland's own record in failing to meet targets and unfortunately being one of those most at fault, particularly within the EU. We're also today marking the launch of our International Human Rights Law Clinic, which is an LLM program being led by my colleague Dr. Maeve O'Rourke. And a number of our students are here. I'm delighted that they've travelled today. And one of the key strands of that human rights clinic is the focus on climate justice and developing those lawyering skills to bring a human rights-based approach to our response to climate change. So I'm going to hand over today now to our chair for this afternoon, and we're very grateful to the Chief Justice, Honourable Mr. Justice Frank Clarke, during an extremely busy week. Very thankful to him for agreeing to chair and to open today's event. And as I'm sure you all know, he has a very long track record of commitment in terms of promoting access to justice and also highlighting the importance of Ireland's developments in the field of environmental law. So thank you very much, Chief Justice.
Thank you very much. I've only two functions at this stage. One is to give a brief introduction, and secondly, to introduce our keynote speaker, Professor Alston. I've often commented in recent times that the workload of the Supreme Court in the environmental field is one of the more surprising developments from the establishment of the Court of Appeal some 5 years ago. And while I think it's fair to say that not all of the environmental cases with which the Supreme Court is now concerned are even indirectly relevant to the concept of climate change, nonetheless some are, and I suspect that's going to increasingly be the case. For example, the Fitzpatrick case that was heard down in Galway earlier this year, actually in NUIG as it happens, was a case which was about whether a particular permission for a building should go ahead, strictly speaking, but part of the backdrop to the case was an argument about data centres in Ireland, the energy demands of those data centres, and the question of whether Ireland could meet its environmental obligations internationally while at the same time allowing for a large number of data centres which had a huge demand on energy. And that perhaps leads to a second point. In almost all the environmental cases, certainly the ones that reach the Supreme Court at this stage, there is an international dimension, normally an EU dimension. And I think that's particularly relevant not directly, but indirectly in the topic of today's discussion, because of all the areas, I think, where international borders don't matter, climate change must be one of the most obvious. Indeed, the places where the issues that create problems for the climate occur are almost always not the areas where the effects are likely to be most acutely felt. And therefore, considering these issues within a purely national dimension is unlikely to be particularly effective. And for that reason, an international view is clearly important. There are obvious legal issues that may potentially arise in Ireland in that context. As some of you may know, the Irish Constitution expressly excludes the direct effect of international treaties which are not the subject of legislation, with the exception of the European Union treaties which are themselves incorporated into the Irish Constitution. And it's for that reason that it's easy to invoke European Union law in the Irish courts, but not quite so easy, certainly in a direct way, to invoke non-EU international obligations. But be that as it may, the international dimension is bound to play a role in the future. And finally, I suppose I have to give a personal health warning. It's by no means impossible that some of these issues may wend their way through the door of the Supreme Court in the not too far distant future, perhaps even before it has come for me to have to retire. And therefore you will understand that I have to be fairly reticent about saying anything, or at least unless any of you think it would be a good thing if I was disqualified from hearing the cases. If you think that, then perhaps induce me to say something indiscreet so I can avoid having to hear the cases, but I suspect it might be better if I just stayed on the pitch. But in order to stay on the pitch, I need to keep quiet at this stage. So I am more here to listen and learn rather than to tell. And in that context, it gives me great pleasure to introduce our keynote speaker, Professor Philip Alston. As Sinead has already said, he is the UN Special Rapporteur on Extreme Poverty and Human Rights. He also is the John Norton Pomeroy Professor of Law at NYU. He has a distinguished record both in the academic field and in the international human rights field. To go through it all would use up most of the time that he has been allocated for his own speech, and I suspect you don't need me to deal with it. But it's fair to say that in the international human rights area, while he has been the UN Special Rapporteur since 2014, he had before that many appointments with the UN and other international bodies in the field of human rights. And the particular focus of his address today, I think, brings together a range of issues which are perhaps beginning to be realised as having a human rights dimension. And for that reason, it gives me great pleasure to introduce to you Professor Alston. Thank you.
Thank you very much, Chief Justice. I'm delighted that you're here and very happy also to be able to speak at the launch of the NUI Galway clinic and to focus the spotlight on the great work that Siobhan Mullally and Maeve O'Rourke are doing in the National Human Rights Centre there. And I'm particularly happy that they're planning to take up the issue of climate change as one of the topics that they're looking at. I'm going to maybe say things that you've already heard, but the problem is no one's listening, so we need to be somewhat repetitive. If Mary Robinson were here, she'd probably be disgusted. Mary and I worked together a lot in the long past days, and I remember her, forgive the expression, banging on about climate change back in the early 2000s, and I nodded and said, yes, I agree with you, Mary, but like most others, and I'll come back to that, my real feeling was that climate change was one of 100 issues that we should really be addressing. You won't be surprised to hear that it's now gone from one of 100 to number one, which is a proposition that human rights people will often find difficult to accept because they don't think that any issue can be number one, but I'll try to make that case. We're meeting here at a time when there clearly is a climate emergency. Even the UK Parliament has recognised that. The science is difficult. I don't know how many of you are on top of the 1.5, 2, 3, 4 degrees of warming above pre-industrial levels and so on. But suffice it to say that the target that we would have liked to come out of the Paris Agreement in 2015 with, which was 1.5 degrees, is now almost comprehensively lost unless there was a revolution across the world. We will be extremely lucky if we get anywhere near 2 degrees, and the prospects are rising every single day that we'll be up to 3 or 4 degrees. And the consequences of that degree of warming are truly dramatic. I'll perhaps leave it to John to talk about that later, but I, of course, come from Australia, which, as you may know from the newspapers, is currently burning furiously. I was earlier, just a few days ago, in Poland for the National Human Rights Congress there, and it was on exactly the same day that the Polish government said it would not join all of the other EU countries in signing up to the new Green Deal. And bizarrely, because there's a climate skeptic government in place, which, like my own government in Australia, will not talk about these issues, people were commenting rather casually to me that, gosh, normally about a month ago the snow would have arrived, actually more than a month ago. Strangely, we haven't had any snow this year. Wonder what's going on. But there was no real preparedness on the part of many to put 2 and 2 together. Let me say that despite the extent of the crisis, we are currently doing dramatically and stunningly little. And that includes Ireland, I'm sorry to say. Greenhouse gas emissions have basically doubled since 1990. And 1990 was a couple of years after the Intergovernmental Panel on Climate Change first blew the whistle and said, we're all in big trouble if we don't act urgently. And what's happened is that we've since emitted more than in the preceding period of history, in other words, from the Industrial Revolution to 1990. So what we're doing is really gearing things up. If you look at the most recent statistics, the plans that governments currently have in place in relation to fossil fuels, oil, gas, coal, would see a 50% increase in production between now and 2030. So you've got the Australian government just giving out a huge new contract, multi-billion-dollar, to develop new coal mines in the north. You've got the Norwegian government, which is so good on so many other things, continuing to explore new oil fields. And one could go on just to demonstrate that all too little is being done. It has to be said that the European Union is actually the standout in all of this. It's funny, I've also been working on, not so much on data protection, but on broader issues of artificial intelligence recently. And it's sort of sad, but also good, that the only place we can look these days for progressive approaches is to Brussels. They are grappling in all seriousness with the urgency of these issues in ways that others are not. So the big question is, where do human rights fit in, and therefore what should the response be of human rights bodies and of courts? I won't spend time documenting the human rights impacts, but it does merit a brief word. We know, I think, that food supplies are going to be dramatically challenged as climates change across the world. One of my all-time favourite fruits or vegetables are cherry tomatoes from Spain. I normally end up buying them in Ireland when I come here each year for Christmas, but those cherry tomatoes are presumably going to have to disappear, not just because of the unsustainable agricultural arrangement, but because temperatures in the south of Spain are going to soar to levels that just are not possible for anyone to live and work effectively in. I could go on in terms of the impact on economic and social rights, the right to housing, the extent to which houses are going to be burned down, are going to be flooded, that whole areas will become uninhabitable, and so on. But we don't really need to get any more information on that. I want to emphasize that if we're only concerned about civil and political rights, which sadly is the case for a lot of human rights lawyers, then climate change is going to dramatically affect what you're doing. First of all, of course, there's the issue of protests. I, unfortunately, am of the school that thinks that, for the most part, governments and courts are not going to come to their senses on this issue without serious public pressure. That, in turn, brings up the right to protest. That, in turn, brings up the legislation which is increasingly being adopted in different countries around the world to impose particularly punitive measures on environmental protesters in order to try to block them out of the picture. Again, my lovely Australia is at the forefront in these initiatives, but there are many other countries where the legislation is simply being ratcheted up, and those who are seeking to use the cherished right of public protest to draw attention are being progressively or regressively restrained in what they can do. I think climate change is going to be an immense threat to democracy. I think along with the proclamation of climate emergencies, we're going to see human rights emergencies for various reasons, because the extent of the change that will be required in most societies will be so dramatic that governments will be arguing that they need to be able to suspend a whole range of rights. And of course we have the much deeper challenge, which is that democracy is showing itself to be pathetically incapable of responding to climate change because its worst effects are going to happen more than 3 years away, or 4 years away, depending on the election cycle in your country. My report to the UN made or tried to draw a lot of attention by using this phrase, climate apartheid. But I want to very briefly explain what that means. If any of you are familiar with the apartheid system, and I'm sure there's deep awareness here. I know that, what's his name? There was a cabinet minister in Nelson Mandela's ministry who was here as a professor at Kata Asmal, who I met in South Africa, in fact. But he spent all his time drawing attention to the horrors of apartheid, and the Irish people were extremely supportive back in those days. But climate apartheid is designed to simply take us back to the apartheid system, where you had essentially 3 sets of people. You had whites, you had coloureds, you had blacks. The whites had all the rights, all the privileges. The browns were treated marginally less punitively, and the blacks were completely excluded from almost everything that was decent in the society. My contention is that climate change is going to have a similar impact. The wealthy are going to be able to avoid the worst excesses. They can simply move. They can move country if they need to. Peter Thiel, a great Silicon Valley supporter of Donald Trump, has already got himself New Zealand citizenship and a large property in New Zealand, which he says is specifically his climate change exit ticket, while supporting Donald Trump, who says there's no such thing as climate change. It's true, first of all, and this is a point I hope I don't really need to make, that human rights violations always affect the poor much worse. It doesn't matter what your issue is, if it's torture by the police, if it's killings by government forces, if it's violence against women. No matter what it is, poor people are the ones who bear the brunt. And that's going to be doubly, quadruply the case in relation to climate change. 65–70% of climate change worst impacts will be felt in the global south. You may well say, well, that's a great relief. They'll be suffering much more than we are. Hopefully, not too many people will take such a ludicrously selfish and unthinking response, but I think nonetheless a lot of people actually think, well, you know, I live in Ireland, we're not going to burn to death anytime soon. In fact, temperature might get better. Philip Alston might enjoy swimming on the beaches of Mayo in the summer more than he has in the past. But of course, as we'll hear, Ireland is going to be affected. I think just comprehensively, poor people are not able to withstand the consequences of the climate disasters. They're wiped out in one go. They can't rebuild their houses, they can't purchase new lands, they don't have insurance, they're not going to get subsidies from the government in the way that people like we will, and climate change is really going to wipe them out. That in turn leads to the whole phenomenon of climate migration, where we really are going to see tens of millions, almost certainly many hundreds of millions of people on the move. Again, just in Australia, a story in The Guardian yesterday about the centre of Australia looking as though it's going to become simply too hot for the Indigenous people of Australia to keep living there. So they're going to be forced into the big cities where racism is at its peak. They won't be welcomed, life will be made more difficult for them. But that's symptomatic of what's happening around the world. Indigenous peoples, again, are among those who are most vulnerable and who risk being wiped out first. Then what I want to mention briefly is that the human rights community have generally not been very responsive to the urgency of responding to climate change. I arrived at the UN Human Rights Council in June of this year, and I think the very first thing I was told was that the European Union was going to advocate biennializing the resolution on climate change, which meant only looking at it every second year, because there's nothing new, there's no need to repeat what's going on. And of course that was accurate in the sense that the resolutions adopted by the Council are meaningless. Calls for a new meeting to be held, draws attention to the urgent need to do something about thinking about doing something perhaps sometime one day. Resolutions which were utterly without practical meaning. For the most part, others in the field, the special rapporteurs like myself, the treaty bodies have been remarkably slow off the mark when it comes to climate change. And yet, as I've said, every single issue that those groups are dealing with are going to be transformed by climate change. I want to mention just briefly one important development, because I want to talk very quickly about the role of courts. The UN Human Rights Committee has actually adopted what they call a general comment, number 36, on the right to life. And in a pretty dramatic turnaround, they've acknowledged that climate change and related environmental threats should indeed be considered as threats to the right to life. That might seem like a no-brainer to you, but of course in the human rights area we know that you mentioned right to life and people say, yes, I'm opposed to government killings and maybe I'm opposed to the death penalty. But millions of people being executed by climate change, about which nothing is done, doesn't fit within that conception of the right to life. I want to, I guess I indicated at the beginning that I was one of those who tended to see climate change as belonging in some part of the list of 100 issues. I'm concerned with, to use the human rights jargon, I'm concerned with women, I'm concerned with children, I'm concerned with people with disabilities, I'm concerned with migrant workers, with Indigenous people, oh yes, and climate change. I think the point that I've been trying to make and that I try to make in my report is that climate change is really going to overwhelm all of those other issues unless we do something about it. And there is actually a strong justification for putting it right up the top of the list because the time is so limited to actually be able to save ourselves from the ravages of it. Human rights NGOs, interestingly enough, haven't really been able to come to grips with this. Amnesty International adopted a strategic plan 2016 to 2019 where they said climate change is not a priority, just like that. Human Rights Watch continues to struggle. Where does this fit in? We're not real experts on these things. We can't do it. But I think that's going to change in the near future. I want to say a word about corporate actors because that's an important dimension. I wish that I could be more encouraging here, but unfortunately what I see, particularly in the UN area, is that there is a pretty dramatic move towards saying that most problems, the Sustainable Development Goals, for example, maybe climate change, should be dealt with through public-private partnerships, which essentially means putting all of the resources into the corporate area and for governments to be mere facilitators. I have seen nothing from almost any corporate actors of scale that would convince me that they are going to take the lead on responding to climate change. Of course there are very good corporations around. Of course there are people who are into renewable energy and who are trying to come up with new approaches and so on. That's great and I praise it. But to think that the corporate sector as a whole is going to lead us out of climate change is ludicrous. In the United States, the American Petroleum Institute has played an absolutely key role in keeping climate change denial going, in encouraging the view that there is no real threat. And yet what we see around the world today, and this is stunning, is that subsidies for fossil fuel activities come to $5 trillion each year. That is 6.3% of global GDP, are subsidies from governments, from you, to fossil fuel companies. And it's not hard to imagine that if that was turned around, I'm not one of these people who thinks it can be done overnight, but we need to start doing it urgently, then those $5 trillion could suddenly go towards building a Green Deal, as we're increasingly starting to call it. So let me finish up. I mean, my basic proposition is that the scale of transformation that's needed is really dramatic, obviously economic. What the European Union is doing in its New Deal, I think, is terrific. It's only a start, but it's certainly going in the right direction. But of course, we need a societal change as well. We need to start changing the way in which we do things, and we need to start changing the demands we place on government. Finally, what can the human rights system and the courts do? First of all, very elementary, is simply acknowledge the problem. Acknowledge that climate change is a crisis and a threat to all human rights, and that those of us working in that field cannot ignore that fundamental fact. Secondly, I think obviously community activism is important, as I've mentioned. We need to build coalitions. Human rights groups certainly can't do this on their own. Environmental groups, community development groups, a whole range of others, but they all need to see that even though they spend all their time working on food or on housing or on medical care or whatever, if climate change is not factored in, they're going to be going backwards very, very quickly. And they can't just leave it to others. No, someone else is doing that. I think, is it Greenpeace? Where's Greenpeace? They're doing it. So we don't need to. Nonsense. What we're going to see is that given the scale of change that's required, there will be immense opportunities for getting things very wrong or getting things right. And if human rights considerations are not a key part of that, again, there's a very big risk that the transformations that will occur, if they don't occur in the next 2-3 years, they will occur in 10 years from now, because then you will all be restricted in terms of where you travel to. I was in the south of France in summer this year for a day, and it was 46 degrees, and it was unbearable, just unlivable. That's the future. I think freedom of information is a very important dimension. I'm aware that the Chief Justice has been a great supporter of that. I think the Aarhus Convention is very important. The new counterpart to that that's been adopted in Latin America is also extremely important. And I think one of the things that can potentially play a very important role in terms of information, not just making it free but available, in a number of countries, including the UK, there is actually an independent climate change committee that advises the government each year. It puts out an annual report and a number of other reports, basically saying what the government is not doing and making an assessment of whether the alleged targets that they've set are real and can achieve the goals that they have set for themselves. In the UK, that body does extremely good work. Doesn't mean they're going to be listened to, but they are empowering the community and they are holding government's feet to the fire. Finally, a question, and maybe the Chief Justice should close his ears at this point, of climate change litigation. Curiously, we see all around the world, both in the global north and the global south, something of an explosion of climate change litigation. And I think this is a very good thing. I don't think it's a panacea by any means, but I do think lawyers absolutely have to play their part in all of this. I don't have time to talk about cases like the agenda case in the Netherlands, or perhaps even more importantly, the Constitutional Court in Colombia, which impugned government targets and directed the government to come up with a more convincing plan for doing what they had committed to. I'm aware that here in Ireland, the recent case brought by Friends of the Irish Environment didn't get anywhere. I can't resist making some brief observations on that case. I think it was extremely disappointing for a case to be, but this is very classic, of course, any of us who are students of judgments know this well, to lay out a groundwork which is extremely progressive, to adopt a very positive approach on standing, to adopt a very open approach to the existence of an unenumerated right to environment with human dignity and so on, but then to simply conclude in essence by saying that this is a matter to which we must defer to the government. I see very little point in acknowledging standing and then the existence of a right to an environment if the courts are not prepared to take those seriously. Now, I acknowledge, because I've been involved in the field of economic and social rights for a long time, that there are strong resistances, and I certainly know that in Ireland, but in many other countries, to courts getting involved in what are legitimately seen as the redistributive responsibilities of the government, of the executive branch and of the parliament. But I think one has to ask in a case like this, is there no limit? In other words, if the government were to say, actually, we now think climate change is a hoax, and there are a number of governments around the world saying that, and we are going to abandon the goals, where does the deference stop? And how do we draw the line between complete abandonment, which might seem a bit easier, and reacting not at all to a very significant downgrading of the measures that governments are going to take? I could go on. I think the court's reliance on the doctrine of deference, which they then equated to the margin of appreciation, is deeply problematic. I think the fact that they pointed to the fact that the European Court of Human Rights hasn't acted specifically, they're right, but that shouldn't in fact stop the courts at the national level from nonetheless considering these issues. They might have noted that the Inter-American Court of Human Rights, maybe that's simply too far away from here, has adopted a very strong and progressive approach on the right to environment and linking that to action taken by governments on climate change. Let me just finish then by saying my bottom line is that climate change is a matter for all of us, that we cannot leave it to others. And no matter where we stand or sit, we need to think, what can we do? Now, it's going to be different. There are going to be great constraints on judges. There are going to be great constraints on various people. But I've always believed in my own career that there are opportunities for pushing the margins. And those who don't push when the opportunities are there, those who don't draw attention to issues, even if that's difficult, are opting out. And I genuinely don't believe that's any longer an option in relation to climate change. Thank you.
Thank you very much for that really fascinating address. I promise not to be influenced by the final comments, and will keep an entirely open mind whenever a case comes before the court. And while I won't talk about that, one point that you made struck me as part of the general question of how it impacts on everyone, including perhaps courts, not in that big picture level, but even at a smaller level. The Irish Supreme Court is part of a number of European-wide courts bodies, and I was struck, perhaps not this year, but the previous couple of years, speaking to colleagues about the particular difficulties that the immigration judges had encountered because of the population movements arising, in this case, out of war in the Maghreb and in the Middle East, and the fact that in many cases courts were overwhelmed, were unable to deal properly with cases because there were just so many and so few judges, which were probably sufficient in number to deal with what one might call ordinary times, but were just overwhelmed. And if you think, while the numbers were extreme, and we didn't really suffer very much for geographical reasons, a little, but not much, but countries that were in the front line, like Greece, had particular problems. But it's not unreasonable to infer that the risk of population movement on a scale that would make that appear minor is a real potential consequence. And therefore, even in the narrow sector of judges doing an ordinary job as opposed to dealing with major constitutional type issues, there's a risk of courts not being able to handle some of the consequences. And I'm sure if we had time to think about it, you could think of all sorts of other areas of ordinary litigation that could be significantly impacted and place demands on courts which they wouldn't be able to meet. So I think ordinary courts, as opposed even to constitutional level courts, may well have their own problems with climate change in the future. That being said, the next speaker is John Kenny from the Human Rights Committee of the Bar of Ireland, and I'll ask John to speak now. Thanks.
Chief Justice, Special Rapporteur, ladies and gentlemen, I only have 10 minutes, so I'll try and pack as much in as I possibly can. Firstly, I'd like just to commend Professor Alston for his report. It manages to deliver what's frankly a terrifying message without a single word of hyperbole, without a single word wasted, and without any exaggeration. It is, in the long series of reports that I've read on exactly this issue, I think it's the one that manages to reduce the essentials down to a very short number of paragraphs. If one is commending materials for people who may be non-lawyers or maybe non-experts in this area, I'd certainly point them towards Professor Alston's report. But I was struck, if one puts Professor Alston's report at the end of the chronology and one looks at expert reports on climate change from the late 1980s to 2019, and one reads them in that chronology, starting at the start and finishing with Professor Alston, I think 5 things emerge if one adopts that chronological approach. The first is the increasing urgency with which greenhouse gas emissions must be reduced. The second thing is the level of scientific certainty in relation to the effects that will result if those greenhouse gas emissions won't reduce. In the early 90s, there was certainly a question mark as to the possibilities of effects. As time has gone on and as computer models have improved, that scientific certainty has shrunk to vanishing point. The breadth of those effects is the third thing. We now know for certain that climate change will affect each and every person on this planet. The fourth thing, and possibly the most striking of them all, is the severity of those effects. In 1997, the New York Times was able to write that a global temperature rise of 3 degrees would be relatively moderate and would be, in essence, benign. We now know with absolute certainty that a temperature rise of 2 degrees above pre-industrial temperature will result in, for example, the complete wipeout of all coral reefs. It will leave 100 to 400 million people at risk of hunger, and will leave 1 to 2 billion people without adequate water supply. And we are predicted to arrive at that 2 degree limit by 2100, so in 80 years from now. That's the scale of the challenge. And the final thing if one reads those reports from the 80s to today, it is apparent that those challenges are now happening. Those changes are now happening. The language has changed from will happen, may happen, could happen, to happening today. And they are happening, as Professor Alston identifies, overwhelmingly in the poorest and most vulnerable parts of the world, in sub-Saharan Africa and the Asian subcontinent. So at the same time that our level of scientific certainty has improved, and we now know with precision the effects of climate change and when those effects will occur, there's another trajectory. And the other trajectory is unfortunately the reluctance by governments and the executive to restrain those emissions. So we have this bizarre situation where we know that these emissions are happening. We know that these emissions are going to have these catastrophic effects on people, and yet, as time goes on, it is apparent that governments and executives are unwilling or unable to restrain those greenhouse gas emissions. As identified by Professor Alston in his report, sombre speeches by government officials at regular conferences are not leading to meaningful action. And that, unfortunately, I think applies, that observation applies in this country. The average Irish person emits 13.2 tonnes of CO2 per annum. That's twice what the average Swedish person emits. It's 3 times what the average Croatian emits, and it's 13 times what the average Fijian emits. So we are, I think, in third place in the EU. So that sounds good. Normally, third place wouldn't be too bad. Third place, whatever the opposite of a bronze medal is, I'm not quite sure what that is. But we have that particular bauble dangling around our neck. Most pointedly, and I think most obviously, and it's something that this is all of what I've just said and all of what Professor Alston has just said, coalesces in the National Mitigation Plan. This was adopted in 2017, and the National Mitigation Plan actually approved an increase of emissions over the lifetime of the plan. Just allow that thought to just coalesce in your head for a minute. The National Mitigation Plan, in light of all that we know about greenhouse gas emissions and the effects of climate change, the plan passed by the state actually envisaged an increase of 10% in emissions over the lifetime of the plan. And you can pick a number of examples of where we've gone so badly wrong, but I'll just give you 4. Firstly, it is a policy to increase the national dairy herd by 50% under the Food Harvest 2020. The Minister for Climate Action expressed his profound disappointment that a peat-fired power station was going to cease operation next year rather than 2030 because an environmental NGO had intervened to point out the insanity of burning peat. Thirdly, the government is continuing to express its support for the Shannon LNG gas terminal which may be built in County Kerry, despite absolutely unequivocal evidence to the Joint Oireachtas Committee that greenhouse gas emissions from the imported LNG, which will come from fracking in the United States, will be approximately 50% more carbon intensive than the coal equivalent, and we all know just how bad coal is. And finally, the state's own Climate Change Advisory Council described our emissions as frankly disturbing. So that's where we are. That's, in my respectful view, it's quite clear that the state is incapable of restraining greenhouse gas emissions, certainly in this country, and Professor Alston has given examples across the world. So we have one trajectory where we know greenhouse gas emissions are going up, we know the consequences of them, but yet we have another trajectory of executive action, and I think that's our executive inaction. I think that's why the topic of today's talk is so germane, because where the executive is incapable or unwilling to step in to restrain these consequences, human rights gets pushed, willingly or not, into the forefront of the debate. And it seems to me that human rights, it talks to both trajectories. One, firstly, human rights are impinged, are breached by each and every human right, major human right, is breached by the possibility or by the consequences of greenhouse gas emissions. Secondly, human rights is the tool by which traditionally we have restrained executive inaction. It should be the perfect tool to address the issue in which, the difficulties in which we find ourselves. But as Professor Alston identifies, the contribution of human rights to this particular crisis has been marginal thus far, and it's just, that raises the question: why is that? Why has this perfect tool failed to make a more significant contribution to the debate so far? I'll just conclude by just identifying why I think that might be the case. The human rights discourse was designed or arose in circumstances where I could identify a specific breach caused by a specific act perpetrated by a specific person, and I could put all of those actors before a court and ask the court to intervene to stop the particular individual from perpetrating the particular rights breach. Climate change doesn't fit that narrative. If I take a flight between here and New York, it has an effect on a farmer in the Punjab, but it's very, very difficult to link the consequences of my arriving into JFK with the monsoons that are now wiping out the farmer's crop in the Punjab. Secondly, and I think that really, and it's something that we have wrestled with in this jurisdiction in relation to the Volkswagen emission scandal, and in a slightly different context in relation to Ryanair. Ryanair is the 10th largest contributor of CO2 emissions in Europe. It is headquartered in this country. It produces the same or more CO2 emissions than Cyprus, than Latvia, and it produces 3 times as much CO2 emissions as Fiji, the entire state of Fiji. And yet, if I was to institute litigation against Ryanair seeking to restrain the CO2 emissions which it emits, or to put a Fijian gentleman before the court and say the consequences of Ryanair's greenhouse gas emissions are the inundation of my client's home, I would face an insuperable difficulty in terms of causation. I can't prove that causal link because climate change simply doesn't fit into the conceptual box in which human rights discourse has developed. So what can we do about it? The first thing I think we need to do is take Professor Alston's advice that extraordinary situations require extraordinary responses seriously. I think we need, with some immediacy and with some urgency, to look again at venerable concepts around standing, around evidence, around causation, around the separation of powers, around how we allow courts to vindicate human rights, but without trampling on the prerogatives of the executive to reduce greenhouse gas emissions and to select the appropriate way to do that. I only have 10 minutes, so I can't say what they might look like, but it strikes me that we need to have those conversations, and we need to have them urgently. I just want to finish with 3 very brief positive notes. And it is difficult to be positive, but I'm going to try. The first is the Dutch case in Urgenda. All of these traditional issues, all of these traditional defences about policy being the preserve of the executive, causation, were all raised by the Dutch government in that case, in trying to meet the Dutch NGO's litigation. They've been comprehensively rejected by the Dutch court twice, and the Procurator General, the Advocate General to the Dutch Supreme Court, has issued a very strong opinion, again rejecting them. And just, this was being very topical, the Dutch Supreme Court's decision is tomorrow in our agenda, so very much watch this space. But I think the Dutch show us an example of how we can recalibrate our understanding of legal concepts in order to address a crisis of this magnitude. The second possible point of optimism is the decision by Mr. Justice Barrett in Merryman versus Fingal County Council to recognise an unenumerated right in the Constitution which arose in the context of climate change litigation. The status and the scope of that right remain to be identified, and that may be one of the things in Mr. Justice Clarke's bulging inbox. But it is, whether one agrees with it or not, it is at the very least an imaginative approach to the issues raised uniquely by climate change litigation. And then the final thing, it struck me when I was in the High Court in the climate case, when the court was packed to capacity by people who have no understanding or engagement with the legal system and who regard it as a largely alien concept that's done by other people in dusty courtrooms and that they don't greatly understand. It really did strike me that we as lawyers and as barristers in particular have a particular skill to transmit very complex things in understandable and comprehensible format. And I think that's a skill that we can usefully apply, whether through litigation, whether through engagement with broader society, with civil society, in order to advance public understanding of this crisis, in order to build consensus, in order to diffuse tensions. It is something that I think we as barristers can usefully do as we move to try and address the unique challenges raised by climate change. I commend the Special Rapporteur's report. I'm very much obliged.
Thank you, John. I discerned in that address some elements that might, in slightly different language, find their way into arguments that I might have to listen to in a different context in the not too far distant future. And if I might add one small point to that, perhaps it's interesting that some of the more recent decisions of the Supreme Court, which haven't got the attention I think maybe that they deserve, are beginning to suggest that perhaps a better way of looking at the rights that aren't expressly referred to in the Constitution is to consider them as derived rights rather than unenumerated. Because unenumerated kind of almost gives the idea that the judges make it up of a Tuesday and decide what they think are rights. Whereas perhaps a more fruitful way of looking at these things is to say, well, if the Constitution guarantees a right to life, a right to health, dignity and the like, well then it derives from that other practical expressions of those rights have to occur. So I've listened to your argument. You probably now listen to one of the questions that you might be asked if you're there. But that's, of course, totally off the record. The third speaker is Dr. Maeve O'Rourke, and of course we are here in part to welcome the launch of the International Human Rights Law Clinic at the Irish Centre for Human Rights. And can I just take this opportunity, given that I'm here back in my hometown of Dublin, to thank very much the Law Department in NUIG for the welcome they gave to the Supreme Court when we sat, not just in Galway, but in the Aula Maxima of NUIG earlier this year. And I'd like to think that the engagement between the court, the faculty, the students and others in the legal community in Galway was a very valuable experience all round. And I'm happy to say that our experience has been good enough that we're off to Waterford and Kilkenny next year and off to Castlebar and Letterkenny the following year. So we have clearly benefited from our engagement with you, but that's an aside to the principal purpose of being here today. And I'd ask Maeve to tell us about the launch of the clinic. Thank you.
Thank you very much, Chief Justice. And before I begin, a huge thanks to the Bar of Ireland's Human Rights Committee, whom John was representing so ably there, but we're really thrilled that we're co-organising this event with the committee. I'm delighted to be here to launch our LLM International Human Rights Law Clinic today. It's a real privilege to do so in the presence of such a diverse and committed community of human rights lawyers here today, and students and activists. And I do believe it's important in practice and symbolically that we're launching it with the enormous challenge of climate injustice and all of its components, structural inequalities and power imbalances at the very forefront of our minds. There is a fuller description than what I'll be able to give on the website of the Irish Centre for Human Rights. So I just want to touch on a few key things. First of all, what is the model and the theoretical basis for our International Human Rights Law Clinic at NUI Galway, beyond the fact that students, of course, should bring their human rights sensibility and their legal knowledge to bear on practical issues and then get credit for working on them? Well, the clinic is designed to introduce students to the notion of movement lawyering, or the related concepts of social change lawyering or revolutionary lawyering. For example, as American poverty lawyer and academic William Quigley discusses, or indeed the related notion deriving from Gerald Lopez's book in 1992 of rebellious lawyering, a very radical concept at that time. The basic idea being that lawyers, and in our case, law students or people with a legal background or knowledge, can and should work towards social justice and human rights aims by partnering with community-based grassroots movements, which are there for the long haul, who are the ultimate experts in the complexities and realities of what they are experiencing, and who need or could benefit from law in myriad different ways. Litigation may be one of the tools that a community or community organisers have chosen to use to achieve the social change they're seeking, but it's certainly not the only method by which lawyers, whether practicing or academic, or indeed law students or those with any knowledge of law, can contribute. And I'm really, I suppose, gratified in a way by John's concluding point, which is that he's realised that barristers have huge skills to offer, not just in the courtroom, but in producing understandable explanations of very technical concepts, whether they're legal or scientific, in the community as a whole. So that's a very exciting thought, John. Our clinic and the literature on movement lawyering and those related concepts also aim to challenge the idea of the heroic lawyer, or the lawyer who knows better, or the lawyer who has nothing to learn from the non-legal approaches or perspectives of others. So it's interesting in our particular clinic that the students who come to the Irish Centre for Human Rights to study for a master's in human rights law do not absolutely have to have a background in law. They don't need a legal degree as long as they have a background in something relevant. So many of our students do not personally identify in the way that some might argue lawyers are trained to identify as having a knowledge that sets them apart, but you do see that notion has influenced them nonetheless. And so our clinic is involved in what I think is also a really important societal aim, which is to, as Gerald Lopez wrote about in 1992, demystify the law for people who aren't those with legal backgrounds, but also vice versa, to demystify the experiences of those who are experiencing human rights violations for the lawyers. In our clinic, the students learn about human rights issues and movements, which will be the focus of their projects, from their own in-depth research, but also crucially from community organisers working in the area on a daily basis. And these people have visited our clinic, and crucially, those who visited have not been lawyers themselves this year. They come with requests, but they also finesse those requests over the terms, the 2 terms that the students work with them. And the students individually contribute 80 hours over 2 semesters, but they work in groups of 5, 4, 5, 6 together on projects. With a view to ultimately making human rights arguments, or given their human rights perspective, their contributions are diverse. The students might, for example, gather evidence through freedom of information or parliamentary question requests. They might archive information, they might analyse international, domestic, or comparative law and write reports. They might draft correspondence to human rights bodies. They might draft responses to parliamentary or governmental consultations. They might try to draft legislation. They might, in fact, try to draft websites. They might write public information guides. They might write newspaper or blog pieces. And they might engage in other types of multimedia production. The process of doing all of this might be messy, and you can imagine that they might well need to go and find other people other than me and even other than the community groups that they're working with to get some answers from and to get guidance from throughout the year. In our clinic this year, which is the first year, we have 25 students working in 6 small groups to see if they can provide assistance to a number of unpaid, community-based advocacy groups. Or more generally, if they can provide a public contribution on an issue that those groups are working on. Students have started to learn from, and 2 groups are working with the movement of asylum seekers in Ireland, MASI, with the aim of providing useful research and legal analysis and possibly suggestions for further public advocacy. Another 3 groups are engaged with Adoption Rights Alliance, Justice for Magdalene's Research and others to see whether they can assist in public education about the need for national memorialisation and truth-telling about our so-called historic institutional abuses. Another group seeing whether they can provide assistance to survivors who might wish to use the EU General Data Protection Regulation to access their personal data. And also another group working with archivists in NUIG Library to see how, bearing in mind the well-known gagging clause that applies to survivors who went to the Residential Institutions Redress Board, to see how they might help survivors to upload onto an online archive the information that they wish to make available to the general public. But finally, and by no means least, particularly given everything we've discussed here today, we have a group of 5 students who have started to work with Safety Before LNG, a North Kerry-based local group of activists who have been very involved for a long time in trying to do everything that they can to resist what they see as the impending importation of US fracked gas into Ireland. So at the moment, the students are trying to understand this group's concerns, which are, in very basic terms, first of all, the need to ban the importation of fracked gas, both because of its impact through methane emissions on its way here once it gets to Ireland, but also, of course, because of the impact on the communities where it is coming from. Second of all, Safety Before LNG have been talking to the students about their experiences, and they are non-lawyers, of the EU avoiding what should be the environmental impact assessments through undertaking various procedures that they say can get around the assessments that should be happening. So they've talked a lot to students about the PCI list and about the European Commission calling things policies instead of plans. And finally, they're talking to the students about their major concerns about weakening requirements for consultation and civil society participation and accountability when it comes to climate impacts and environmental impacts in Ireland of strategic infrastructure plans. They're talking about the Strategic Infrastructure Act 2006 and the standing proposals in the Planning and Development Bill. So, to conclude, there are massive opportunities, I think, to the students who take this clinic, but also from the notion of movement lawyering or rebellious lawyering or social change lawyering for all of us. We can see, and we've heard from Professor Alston's presentation, that the issues we face when it comes to climate change are massive, they're complex, they're structural, they involve huge embedded power relations and power imbalances, and it is movements that are going to make the difference. So it's exciting getting students involved, and from a personal perspective, being involved in movements for change does create a sense of hope, it creates solidarity, it creates feelings of camaraderie, and it's hugely empowering and satisfying to see that legal skills can combine with a whole range of other skills and activities. There are challenges, of course. The first one, I suppose the primary one, and we even see it in students, and it definitely applies to all of us here practicing or academic lawyers, is that climate injustice is political. William Quigley says, we've been taught to believe that radical change is impossible, or at the very least, very, very dangerous. And we do see this even in the students' perceptions. And I have had at least one student concerned that what I'm asking them to work on is a local political issue and not something that a human rights student was expecting or should be working on. So even worse than being political, it can be seen as a local political issue. And you will have noticed that the clinic is called the International Human Rights Law Clinic. And it is deliberate that my aim, at least as we start out, is to show that international human rights violations, i.e. violations of what are international human rights norms, but what we also see in European and domestic law, happen at a local level. And they happen in a political sphere, and they happen to people, most of whom are not lawyers, and who need, and I suppose are entitled to, work alongside those who have the legal knowledge that can contribute to changing the situation. And finally, I suppose another challenge is that the issue of climate injustice is technical. I am not an environmental or climate justice lawyer by training, although I am a human rights lawyer, and I definitely have felt both intimidated but empowered by statements like we have from Professor Alston, essentially saying that we all just need to roll up our sleeves and get involved in whatever way we can. So the clinic is a huge learning experience for me, and I think climate injustice is an opportunity for all of us to see what we can learn. So to conclude, again, another quote, my last one, from a document that I give out wherever I go, and had I had a giant printer would have given to everyone today. It's a short document by William Quigley, 10 Questions for Social Change Lawyers. And he says, and this is what is the opportunity but also the challenge of the clinic, that social change lawyering is a process, it's not an achievement. It's a path we walk with others to confront the root causes of injustice. What lies ahead is not known, there is no map, but our directions are set by constantly checking a compass that points towards justice. And we know the difference between law and justice. There are obstacles that force us to change directions, but there are ways of going forward. So thank you very much for being with us today for this launch.
Thank you very much, Maeve, for introducing us to what I think will be a very valuable experience for the students who participate, but also, I think, for those who they seek to help. It's always good when you have a win-win situation. Many matters that come before the courts are issues where there's undoubtedly going to be winners and losers, but it looks like this clinic has the potential to provide only winners on both sides. Now, Professor Alston has agreed to take a few questions between now and 2 o'clock. So is anyone brave enough to be the person to ask the first question? Down there on the right, yeah.
Thanks, I need a microphone, but thank you very much. That was a fantastic opening session and really enjoyed the speakers as well. My question is just quickly for Professor Alston. I really enjoyed your work as well on Ireland's status as a tax haven and coming out strongly against that as well. And I'm just wondering, considering where we are, but also in general, there's been a new report in the Nature, Ecology and Evolution Journal by the Global Economic Dynamic Institute, and they found that Ireland was used as a tax conduit into the destruction of the Amazonian forest. So investments in soy and beef products were funneled through Ireland into tax havens, and obviously that's incentivizing the destruction of those forests. So I'm just very interested in the intersection between what is a perfectly legal tax efficiency or tax tax efficiency procedure within law at the moment, and also the human rights implications of that. And secondly as well, I've just finished a really interesting project with the National Economic and Social Council on examples of just transition around the world. And one is fantastic in the Latrobe Valley in Victoria, and a brilliant example as well of a coalition of and an interdisciplinary approach that you mentioned in your recent report on poverty and human rights and climate change. So I'm just wondering if you've heard of that, and also as well, do you see any more work on interlinking human rights and just transition approaches? Thank you very much.
Yeah.
Do you want to speak there?
Yeah. So, yeah. Well, I know that tax is not a sensitive issue here in Ireland, so I can I can jump right into that one. I'm here until the new year. I don't want to be attacked in the street. I mean, I think that what we're seeing generally around climate change is an effort to broaden out to address other dimensions. So the new EU arrangements contemplate that the EU won't enter into new trade agreements, for example, with countries that haven't accepted Paris commitments and are doing something serious about them. I think the OECD has just brought down a big report about the opportunities for international development assistance to be geared to climate change and not just providing financial support, but provoking reform. And I think the same applies in relation to the tax regime. We are ever so slowly trying to close down some of the massive loopholes. It's all right, you can relax, it's not going to hit you yet. But I think climate change needs to be an important part of that. On the second question, I actually know nothing about the Latrobe Valley that you mentioned, although it's very close to where I come from. But I haven't lived in Australia for a long time. I think that one of the things that is most exciting in a way is that climate change is at the top of the agenda, but underneath it are a whole range of other issues which require us to contemplate doing things very differently. And climate change may just be the lever that forces us to take those other things much more seriously than we might. But that, as I said, makes it all the more important for us to make sure that we get it right and that it's human rights consistent.
One here first, and then yeah.
Thank you. As a question about urgency for Professor Alston, as the panel knows, we're at 1.1 degrees Celsius above the pre-industrial at the moment, and according to the most recent IPCC report, we're likely to hit 1.5 degrees between 2030 and 2052, 2 degrees shortly after that, so potentially mid-century 2060, at which point, as John said, all coral reefs go extinct. And even if all of the nationally determined contributions were delivered under the Paris Agreement, we're on a trajectory for 3 to 4 degrees by the end of the century, which our own EPA has said would essentially mean the world that, as we know it, disappearing. You know, and that's not an institution known for its overstatement or its hyperbole, I suppose. And in terms of the impacts that you talk about in your report, Professor Alston, the World Health Organization has estimated, based on a very conservative group of risks, that 250,000 additional people will die each year from 2030 to 2050 as a result of climate change. And my question is just, what is your assessment of whether the law is capable to respond with the urgency required to the scale of the impacts that we are likely to see in our own lifetimes?
Well, I think first of all, one thing that bears noting, although it raises other problems. There are pretty strong critiques of the Intergovernmental Panel on Climate Change, and perhaps from what you said, the WHO panel, using unduly conservative measures because they have been subjected to such attacks from the fossil fuel industry that they just cannot afford to speculate, if that's the word, obviously. Well, they can't afford to speculate, but they can't afford to really be illustrating the full likely impact. And so much of what we've got is almost certainly an underestimate of the effects. The question of whether law can do it, I don't want to go back on anything that I said before, but we have to keep the role of law in perspective. I mean, my approach would be that the courts in a great many countries are not doing what they could and should do, but I wouldn't suggest for a moment that they are the front line. The front line are the legislatures, the ones who are adopting these very weak standards. And the courts can only play their traditional role of prompting, of highlighting gaps, and trying to push through wherever they legitimately can. But I think it's essentially politics.
Some of those. Sorry, just in the front there.
Hello, and thank you for all of the excellent presentations today. I work with Christian Aid Ireland, who I know you're familiar with from the tax work that we've done. And something we've been researching more recently is how business and human rights and that agenda can actually interact with environmental rights and protections. A lot of us in Ireland will be familiar with the case where 90% of Ireland's coal is imported from one mine in Colombia called the Cerrejón mine, which has a lot of detrimental human rights abuses. And what we've been trying to do is how can we understand this model where we have so many aspects, the state purchasing of coal from a mine that has human rights abuses, as well as the headquarters of that mining company's marketing branch being based in Ireland for tax purposes, and how we can bring in international human rights models to actually help deal with those consequences. So we've been looking at the business and human rights model and how that can interact, and actually the gap that has for dealing with environmental issues, because it's not very explicit. So I'd be interested in really any of the panel's kind of thoughts on that. And then I suppose just a very quick one is also, growing global militarization and the amount of money that's being put into that, and also the fact that emissions from global military aren't counted under the Paris Agreement, and how we can move forward with starting to understand better how to draw those connections together between human rights, global military, and a whole sector of emissions. I think it's equivalent to the size of Switzerland in terms of emissions from a sector that's actually not being counted and kind of exists outside of the rules.
I think I don't have any question in terms of the military dimension. It's clear that the US Defense Department, whose budget was just increased ever more in the last couple of days by the Congress, is one of the world's largest emitters, and we do need to focus on that. It's a curious thing that at the same time as you've got the administration saying that there's no such thing as climate change, that the Defense Department has actually been doing a lot of emergency studies for a number of years now. How should we be adapting what we do? Because, of course, they deal with real risk and they're not prepared to take the chance of being caught unawares. But the government, on behalf of the people, no, don't need to worry about those risks. In terms of the Colombian example, I'll just make one general point, which is probably not the one you wanted, but when we look at the role of government in a lot of these areas, or the role of the courts, we too often think in binary terms. So the courts can't deal with anything that involves resources. That's it. As though the alternative was that suddenly the courts are going to take on everything that involves resources. I think it's the same with a government in terms of tax arrangements. There must be some arrangements that fall outside the limits of what is tolerable. And that it's not a matter of saying, well, we either let everyone send their money through Ireland, or we don't. We can't start picking and choosing, and I think that's a false way of looking at things.
Thank you very much. If Attractive Rin from the Irish Environmental Network, if I might be permitted just to make an observation, just to add to the appalling vista and landscape. We heard about the rise in emissions and the effect of that. We heard in a second dimension in relation to the unwillingness and the incapacity of governments to be able to tackle and address it. And I would suggest there is a third dimension, which is the very active efforts of our current administration to curtail citizens' rights and access to justice with a particularly draconian piece of legislation that has been proposed with the heads of a new bill, which proposes radical changes to curtail access to justice in Ireland. And even the public consultation, if I can dignify it with that description, was intended to run from the 9th of December to the 13th of January, at a time when nobody can effectively publicly engage and participate in that. I think it's a signal of how unwilling our government is actually really to let these movements and people have a voice and a real say in their failures and their omissions, and the bad decisions that they are making in this space. And I would urge people, after some effort, we have managed to get an extension with the support of some key members in the Oireachtas to the 27th of January. And I think it's critical that the types of concerns that have been expressed here, people give voice to them in that consultation on the Department of Housing, Planning and Local Government's website. If I could then move just to a question to Professor Alston in light of his comments about the EU and playing, well, certainly better than most role in relation to climate action. If I could just ask him maybe to comment on the EU's trade policy, particularly in relation to deals like the Mercosur trade agreement and the effect that that is having, effectively fanning the flames of the deforestation and the Amazon forest fires, and the expectation of the thousands of tons of soy and thousands of tons of beef that they expect to be able to sell within the EU. And secondly, in relation to the investment arbitration systems in those trade agreements, which basically instill a regulatory chill on governments in taking proactive action on climate change, which would impact on developers' or corporates' profits. And also they're very uncooperative and non-participatory engagement in the new UN Convention, which is envisaged to hold transnational corporations and other business enterprises to account. Thank you.
I think the answer is clear, yes. I mean, you've raised so many issues I can't possibly... let me just take the very first one of access to justice. I did a UN mission to the United Kingdom about a year ago, and one of the things that really shocked me is the extent to which access to justice has been slashed by government spending, and I think that has gravely damaged the rule of law. Sadly, it may well be that we will see more of those sorts of policies, but we as lawyers certainly should be pushing back against it, not just in our own self-interest, but because if people don't have access to the courts, then the system is just for the elites.
There's someone in the front here who's been trying to get in for a while. I've noticed that John Kenny has had to go, and that is because he has to mention something in court, and that reminds me that we are close to the end, so there'll be one more question after this.
So my question relates to the school strikes. I'm sure many people in the room were really inspired by the work of Greta Thunberg in mobilising people. And so I suppose what I'm interested in is how, obviously there's limits to what that can do. There was calls that workers would be able to strike alongside, and obviously in circumstances in Ireland where there's no political strike. I just wonder, have you anything to say or any ideas about how we might, as a kind of climate and human rights movement, be able to tap into the kind of mobilising resources of unions?
Let me first pick up on the Chief Justice's point and say that I don't think I've ever been with a Chief Justice before who has stayed for the duration of such an event, and I'm deeply impressed. I mean, I'm not sure what I can really say about. I think, as I said, there need to be coalitions. The sad thing is that in many parts of the world, unions are becoming increasingly isolated and lacking in power. Even the IMF, in its analyses, attributes that as one of the key factors in increasing inequality, because when workers don't have the capacity to bargain, then all the profits go elsewhere. So I think building coalitions is absolutely essential.
We have time for one more question. The gentleman in the middle has been trying to get in for a while too.
Thank you very much. I'd like your opinion, Professor, on the UN, some critical flaws in the UN. If we think about the recent COP and its failings, we're now looking forward to Glasgow. People are hoping that's going to make a difference. The UN, by its definition, the United Nations, each nation will prioritize its own individual agenda. This is crystal clear. It is a formula for failure. There's been very strong case made by a number of the speakers about making space for civil society movements and some rebellious lawyering. We need some rebellious lawyering to get non-state parties participating at the same level as states in the UN process. In other words, we need to change the US process dramatically. I'd like your opinion on that.
I don't mean this in a hostile way, but all of the big corporate actors would be delighted with your proposal. Of course, they would be there lining up instantly. I can't really defend the UN against your critique. The trouble is that, of course, it's not the UN, it's states. The Australian government had a brilliant result from the COP25. They blocked all sorts of things and came back crowing about it. Of course, they got burned when they arrived at the airport, but I think we do definitely need to be looking for different mechanisms. I think the mechanism that has been set up has not been successful. I don't see any great reason to think that COP26 is going to be any different. I'm very ambivalent, I have to say, because I have spent in my life a lot of time around UN meetings and conferences and so on. But I have always worried that sometimes too much time and effort is put into them rather than into the real work on the streets, in the legislatures and elsewhere. I come back, I think, closing word, it's really up to us. In other words, what can you do vis-a-vis the Irish government and other actors, and what can I do vis-a-vis a whole range of others?
Well, we're now, I think, 15 minutes over the time we were meant to finish this question and answer session. I think that's just a testament to the great interest in the topic and the interest in the way in which it has been addressed by our speakers. And I think rather than prolong things any further, can I perhaps ask all of you to show your appreciation of all of the speakers in the traditional way.
Well, thank you for staying the duration. I'm very impressed.
Just on behalf of the Irish Centre for Human Rights and NUI Galway, just a huge thank you to Professor Alston, to the Special Rapporteur and to the Chief Justice for agreeing to chair and host today's event, and to the Bar Human Rights Committee also. Thank you. And sorry, there are some refreshments just